Welcome to this special edition of Legal AF. I am absolutely thrilled to be joined today by my colleague, who's also a CNN legal analyst, Shan Wu. Shan, you are a former federal prosecutor and counsel to Attorney General Janet Reno and a current, very, very well-respected white-collar crime defense attorney. I'm so thrilled that you are here to talk to us and that you are willing to share with us your thoughts on, I think, a really, really important issue involving Joe Biden's handling of classified documents. Special Counsel Hur did publish his findings this week, and I read them, and the coverage is so different from what the report said that it's actually shocking to me and has made me go back and look at it to see, did I miss something? I mean, it is so surprising to me how incredibly skewed and misrepresented the findings of the report are. And you have been doing some excellent writing on this, as have others like Andrew Weissman and Ryan Goodman and others, on really pointing out what the what the report said. It didn't say the propriety of certain things in the report, et cetera. And I am so incredibly honored and thrilled that you are here to help the MeidasTouch listeners and followers hear the truth and hear the judgment of somebody who has the experience you have. You worked for an attorney general, right? Like Merrick Garland is an attorney general, and Merrick Garland has a role in a special counsel, and a special counsel is different than an independent counsel. And I hope you'll explain all of that and give us your experience and your judgment as counsel to a United States attorney general, who I'm sure also was very familiar with the rules governing special counsels. And if you could just take us through it all, we'd really, really appreciate it. And thank you so much for being here.
Oh, of course. I'm happy to be here too. I mean, your voice is a really important one in this kind of service where we get to talk about the issues, for longer than, 30-second soundbite. I think is really helpful for folks. So I think going back to the special counsel regulations and the distinction between the old independent counsel statute, a little bit of history, which is Janet Reno appointed an enormous amount of independent counsels under that statute. I think that earned her a lot of irritation with the Clinton administration, but there's something like 7 or 8 of them. She just kept appointing them, boom, boom, boom. And that statute was very different. It's no longer in effect, but under that statute, the independent counsels really worked very much apart from DOJ. They were like their own little mini DOJ. We had staffs, obviously. I worked on one of those. It was the investigation of Bruce Babbitt, the Interior Secretary, and I led a whole section of that. And it's really like having your own little Justice Department. And although we had liaisons with the criminal division to sort of, talk to them, keep them apprised, unlike the current special counsel regs, we weren't actually answering to the Attorney General when I was on that investigation. And that's an important distinction here, not only in the Mueller probe earlier, historically, but also with the current one that Hur just concluded on President Biden, because under the current regulations, which were promulgated during the Reno era, actually, and they decided to let the old independent counsel statute go away, that there have been so many permutations of it and constitutional challenges, like what is the independent counsel if they're not under DOJ? Are they like an independent agency? Once upon a time during Iran-Contra, they were kind of like quasi-legislative judges. So it's very confusing. And I have to say that I think it is fine that it's simply today under the umbrella of DOJ. And today's special counsel regs recognize that if there is a kind of a case where there could be at least the appearance of conflict, or in the instance of Biden, where you would have the Attorney General theoretically running the investigation of the person who appointed him, then it makes sense to try and put a little bit of arm's length in there to bring someone who's from outside the department. They might have been a former Department of Justice person, but they're outside, and they get a pretty hands-off type of autonomy as they run the investigation, but they do have to answer to the Attorney General, and they do have to follow the same guidelines, the same principles and protocols that any other DOJ attorney would have to do. And that becomes very important in the her matter, because I think a lot of what we're seeing, I think, is due to two reasons. One, I do think that her wrote this in a way that I think, as Joe Scarborough put on MSNBC, I mean, he couldn't actually do a criminal charge, so he made a political charge. I mean, in his executive summary, where no one can miss it, is where he uses that very ageist language that, he's like basically an old guy who's well-meaning, but, pretty doddering kind of. By putting it out there in that upfront summary, he guarantees that the media is going to fixate on that, because after all, the age thing has been the big issue, with Biden and with Trump. So a lot of that we can get into it more, Karen, but I think that's very deliberate. But the problem for the media, I think, is twofold. I mean, one, that is a grabber for them. They want to talk about that issue. And then two, the way that her wrote that summary, they've seized upon kind of a misleading headline. And I'll be specific, and I tweeted about this. And then, as you mentioned, Ryan and Andrew Weissman, Ryan Goldman and Andrew Weissman, did a deeper dive to show that it's more than just one instance of misunderstanding. So the instance that I pointed out was in the New York Times article. They made this statement that her had, HAD, the investigation had found that Biden willfully withheld, disclosed. That's actually wrong. They didn't find that, because the word had indicates they concluded that. So that makes it sound like, oh, we looked at the evidence, we found that he had committed this crime, but we chose not to charge him for other reasons, most notably because we think he's a doddering old man who's incompetent. That's actually not at all what the report says. Hers actual language is they uncovered evidence of the mishandling, and then it goes on to state that it was insufficient evidence to charge. There's other places which make it plain that they did not find evidence to refute innocent explanations. Plain English, you're looking at the case, there's not enough to prove that the guy committed the crime for you to charge the crime. If we think of that as a street crime situation, yeah, so-and-so was at the scene of the bank robbery, so we uncovered evidence that he might have committed the bank robbery. But there was innocent explanations. He had an alibi. People say it wasn't him, so we didn't charge him. But instead, with that analogy, the media has simply seized upon the fact that, oh, Biden was guilty, quote unquote, of mishandling these documents, but they chose not to charge him because of the age thing. And so that kind of sets up a lot of this misleading information, which I think at the Justice Security publication, Andrew Weissman and Ryan Goldman do a really good job of pointing out it's not just the New York Times, The Hill, Fox, CNN, I think CNBC as well, all kind of had those erroneous takeaways from that. And it's a little surprising, quite disappointing to me, obviously, and to all of us, because these are very good reporters. I mean, many of these reporters have legal backgrounds themselves, and they are sharp as tacks. It's not like, they're a bunch of lazy folks who just are looking for, headline things. And yet, even with that level of skill and training, they have kind of like misled the public, and unfortunately given the partisan folks, Trump and other Republicans, a way to set up this scenario as, look, I did something, me, Trump, just like Biden did. Even the special counsel said he did this thing, but they're not charging him. So that sets us up for a very confusing and distorted situation, unfortunately.
I think I don't want to completely blame the reporters.
Right.
I blame her. It's the way her wrote it that was actually misleading. I mean, that's the problem. That's why it took me 2 times. I had to kind of go back and look at it, because it isn't, he wrote it in such a way that is actively misleading, in my opinion. I think, so I have a couple questions though. How is that possible? How did he do that? If he has to, if he reports to the DOJ, so he reports to Merrick Garland. Now I would love to hear your theory about why Merrick Garland appointed her. I mean, Merrick Garland seems to be, the Democrats seem to be under this weird misimpression that if they appoint Republicans, somehow the finding won't be questioned. But that seems to never work out that way. It kind of seems to bite them in the behind. But ultimately, this goes to Merrick Garland, who has to presumably approve of this report. Why did Merrick Garland let this go through this way? That's what's also shocking to me.
Yeah, that's a great observation. And just on your point about why was he appointed, I just had a discussion the other night on air with Jim Acosta and Jeff Toobin, and Toobin kind of like, in a nice way, took off my head, because I was like, well, Garland's so concerned with being nonpartisan that no one's ever going to accuse him of being partisan. And I have criticized him in the past for his sort of Garland's over concern about being partisan ends up actually having a partisan effect. And Toobin kind of took off my head saying, but Shan, look at where that's gotten him. All he gets is criticism that he's partisan. So I think that's exactly right. I mean, there's no way that he has avoided that. He's kind of made things worse. But I think you're right. He did choose her because he felt that this was a Republican Trump appointee, and he had served in the Trump DOJ under Rod Rosenstein, who was just on this morning. We can talk about that. And it's interesting what his position was. I'll give you a little bit of the kind of inside DOJ parlance and rigmarole. So the Deputy Attorney General in the modern era is kind of like the chief operating officer for DOJ. Back when Giuliani, was number 3 at Justice, Giuliani ran the department. He was the COO. He was the Associate Attorney General. But in the modern era, it's been the Deputy Attorney General who is sort of like the chief operating officer. And that's what Rosenstein did. And his number 1 deputy, there are a lot of acronyms at DOJ, but the number 1 deputy is the Principal Associate Deputy General, the so-called PADAG. And the PADAG is a very powerful position. It's almost like a chief of staff-ish position. And that's what her was. He was Rosenstein's PADAG. And so he was instrumental in the day-to-day operations, and more importantly, very instrumental in how Rosenstein handled the entire Mueller investigation. So if you look at that historically, there's obviously been a lot of criticism of how that was distorted. Barr later put out this very different version of it in advance of the report being made available to the public. Her was very much involved in all of that. I mean, I can't speak to exactly, what part was his idea, but he would be very, very well versed in understanding what the effect of a special counsel report has. So Garland, on the one hand, is thinking, okay, this guy has impeccable credentials, former U.S. attorney, he's a Republican, he worked very much in the Mueller world, so he knows about this. So no one's going to say, I picked, some hack guy to do this. But I think the terrible mistake of that, besides what you said, which is that goes comes back to bite him on the butt, is that her, of all people, knew exactly how he needed to write the report if he wanted to say something damning about Biden, even if he couldn't charge him. He knew better than almost anybody how to do that. And that's what he did, which is, it sounds like he did do a thorough investigation relatively quickly, unlike the Durham case that dragged on for like a half decade. I mean, he did his work, wrapped it up, got good information. And then he has this situation of, well, I'm writing this memo to say that I'm not going to charge the guy. And, does he sit there and think, okay, how can I really ding Biden? Or is it his natural propensity to kind of like dislike Biden because of his own politics? Who knows? But the way he wrote it, just like you're saying, it's very hard to get to the fact that they found a lack of evidence, and really they found innocent explanations for what had happened. So really what he should have done is to say, look, we did this thorough investigation. Here's the areas we looked at. Here's why each of them does not amount to anything that we would ever charge. And that includes the important points he made about historically, obviously, presidents, vice presidents have left with information, look at what happened to Pence. And maybe he can even say something like, here's some policies we think need to be reworked. The government should look at this, how they're helping people transition out with the documents. But instead, he really wrote it in a way that the takeaway points are more everything that Biden may have done wrong than the fact that a careful investigation indicates there's no criminality here. And I think you're right. I think that's deliberate on hers part. I mean, we can't speak to his deep psychological, motivations, but the way he wrote this, at best, people won't understand how much innocent explanation, how much lack of criminality there is, unless they take, like you did, a second read. And most Americans are not experienced former prosecutors like you and me. The fact that we have to take a deeper dive into it to find that indicates that you're completely pulling the wool, over most folks who are reading this. And I had to do the same thing. I think a lot of our first reactions reading this was like, oh, crap, this looks really bad for Biden. He did all these things. And then as you really look into it, you'll find places where her specifically says we lacked enough evidence to refute an innocent explanation. That's huge for prosecutors. But the way it's put together in that format, you really have to dig some to find that. And that's definitely, I think, her has the skills to have written it that way. And then we move to, okay, why didn't Garland do something?
Before you move past that point, because you make a really, really important point that I just want to underscore and highlight, which is that it's not that it's not that he committed a crime, but there wasn't enough evidence to prove it. He actually didn't commit a crime. There's actually an element of the crime that is missing, and it's intent, criminal intent, or willful retention, whatever the mens rea, whatever the intentionality is here that is required. And I think a good analogy and a way to think about it is, it's not as if it's not even, your bank robbery or analogy is a good one. And another one I think is what's the difference between a fatal car crash and homicide? It's all about intent, right? So you could look at the evidence of that and say, yes, this person was driving the car, this car hit somebody, the person died, and think, oh my God, they committed the crime. No, they committed the act, right? They were involved in the act. But if it was an accident, a complete accident, and the person was just jumped out into the middle of the street and they didn't see it, that is actually not a crime. That's a tragic accident. Whereas if the driver instead, though, hated the person and took their car and ran them over and killed them, that's a crime, because it's all about intention. It's all about why did you do what you did, and all of that. And that's what people, I think, don't appreciate here when they say, yes, but everybody does it, and Biden did it, and Pence did it, and everybody did it. There's a big difference between carelessness, right? Just careless. And Trump could have had if Trump had said, when they asked him for his documents back, oops, I'm so sorry, I didn't realize I had them, here they all are, we wouldn't be where we are, right? We wouldn't be with Mar-a-Lago, documents case. And so I just wanted to underscore that point for people, that it's not that, there just wasn't enough evidence to prove the case, because that's how he phrased it, right? We can't prove the crime beyond a reasonable doubt. No, what he found was there was no crime. And I think that's what's missing. But anyway, I just wanted to underscore it, because I think you make a really, really important point there. But you were about to go ahead.
Yeah, but to your point there, I mean, I think that analogy about the vehicular homicide is a great one, because if the prosecutor was writing a public report as to why they didn't charge the person, they probably wouldn't start it analogous to how hers started, which is, our investigation uncovered evidence that Mr. So-and-so deliberately killed such and such,
Right.
but we're not charging him.
We're not charging him
Instead,
because he's a
right,
sympathetic person and a jury might find him well-meaning. I mean,
right, exactly.
that has nothing to do with why you're not charging.
Yeah,
You're not charging because a crime didn't occur. Because there was no intention
exactly.
to do it. We're there, and even like other little words. I don't know if you picked up on it when he talked about the box of documents that was found with other items of household detritus. Detritus means trash, right?
Right, right.
I highly doubt that he had piles of trash, right, in his garage. He might have had household items,
Right.
like the crap we all put in our, the junk we all, but it's not trash. But even
Yep.
again, those little words, those little word choices to me were just so telling on the perspective and the lens and the lack of objectivity that her had towards the situation. I don't know. The report to me
Yeah.
was gratuitous, and it was a
Oh,
gratuitously partisan um hatchet job. But why so how did Merrick Garland let the report go out? Like, I don't understand. How
yeah.
to talk about that,
I
please.
have to add one more gratuitous thing that Joy Reid pointed out, which is there's a line, I don't know if you saw this, where her says that Biden has always thought of himself as a person of historical import. It's like, that suggests like he's sort of full of himself. I mean, the guy, the guy's been a senator for like Lord knows how long, vice president, and he's a president. Like, is there something wrong with him thinking of himself as having historical import? It's
Yes,
like,
that's objective. Of course,
right,
there's
that's up there.
and there's also historical import with Trump. I mean, it's just that's the way
Right.
it is when you're a former president, and whatever. Like, there's
Yeah,
historical
exactly.
import with all kinds of people. But anyway, that's just, yes,
Right.
you're right. You're
Right.
right. You're right.
So Garland. So under the special counsel regs, it's up to Garland to do a couple of things. First, he decides whether or not it's in the public interest to release the report. So he actually makes a decision on whether to release it or not.
Take one step
Instead,
back, please, with the
yeah,
regs.
sure.
The regs. What do the regs require her to do first, and then talk
Yeah,
about Garland?
yeah. It requires her to explain in a written form to DOJ, to Garland, as to what he's doing and why he's not doing it, or why he is doing something. In a lot of ways, that's similar to what you and I are used to, which is writing a so-called prosecution memo. And sometimes it's a memo justifying why you're prosecuting. Sometimes it's a so-called declination memo saying why you're declining. And in DC, we got to do both street crime as well as white collar crime. And in the rough and tumble volume of street crime, sometimes that declination memo was like, you stop in your supervisor's office and say, this case sucks, we can't do it. But in more complex issues, you are setting forth what the reasons are, what the weaknesses are, and even the weaknesses of the witnesses, and maybe how you think the defendant's going to come across. In that sense, there's a similarity to what hers producing. The difference is it's clear for her and it's clear for Garland that this is something which is likely to be public facing. It's never going to be a purely internal document. So Garland first faced the choice of, does he release it publicly? And he could have said no. I mean, it's just the conclusion, there's no criminality here, I'm satisfied, her did a great job. Politically, he's very worried about that because he thinks it'll make it look like he's covering up something. I mean, repercussions, nothing really. What can Congress do to him? They can try to subpoena him, try to impeach him like they did with Mayorkas. But, he could have made that call. But given the position of being in the Attorney General's position and him wanting to look like we have a lot of transparency, that seems like a tough one for him to just say, okay, I'm not going to show it to anybody. So then we reach the difficult question of, so if you look at this report, and tons of former prosecutors and former DOJ people like me have looked at it and said, this is just way out of line. I mean, former Attorney General Holder said if this was the normal DOJ filtering process, there wouldn't be this kind of gratuitous language in it. So if you're Garland and you're looking at this and you see that, hey, this is kind of gratuitous. There's some pot shots at Biden. The whole way it's written seems kind of slanted. What do you do at that point? So he had the power to talk to her and say, hey, there's some issues with this kind of language. And he could have based them in DOJ, with DOJ has his manual. It's like the principles of federal prosecution. And he could have grounded his objections in that. For example, you're not supposed to kind of take pot shots, personal things, negative things about people. That's part of the principles of prosecution. To your point about if you have the goods on somebody and they're old or they appear sympathetic, that's not a reason to not charge. The manual specifically addresses that. There's a point in there that says personal circumstances can be considered, but if you have a case where someone is very popular, that is not a reason not to charge it. In fact, it kind of leans the other way, which is, if you have a very popular person and you're worried about, will you get the jury to convict them, you should do what justice requires, which is to charge them. So Garland could have pointed to a number of very objective points, not just like, hey, this feels kind of, gratuitous to me. He could have pointed to very specific things in the DOJ manual that says this shouldn't go out in this format. But here's the problem for Biden. The regulations also require that if he disagrees or makes any kinds of changes, not to the report, but just generally speaking in the investigation, then that's something which he's going to have to report to Congress about, not to mention, Republican-led Congress will be all over him asking, what happened here? Was anything that was changed? So he's worried about, what will he have to reveal about what was changed and what kind of bad image that may cause for him and for the department. So I think that's where you see Garland caught in this situation, which is a tough call to make. Do I follow the normal principles of DOJ prosecution and say this is kind of out of bounds, and so we need to revise this, or not? And he clearly chose to just let it go because
yeah, I hear you. And look, when I was at the Manhattan DA's office, I've never worked for the DOJ. We typically, so one of the things that was really important to us was the concept that if a person is accused of a crime, sometimes that's just as bad as if they're convicted. The stain or the tarnish of the accusation can hurt their career, their reputation, just as much as if they were convicted. And so that's something that you have to keep in mind when making public statements about a case, right? And especially if you're not going to charge a case. And so if we weren't going to charge a case, we never spoke about it publicly unless there was a lot of publicity surrounding it, and we felt we had to answer that publicity. But you got to be really careful in what you say because of this stain or tarnish. And I assume that the Department of Justice must have some type of rule, or what you were saying in the prosecution guidelines. They must have something that governs what is appropriate to say or not say. And I wonder if you have a view as to whether the report flies in the face of that.
I think it's difficult to say that the report itself would fly in the face of that because of the fact that there's supposed to be a report when they decline here. But what they cite to in the report, or what he references in the report, for example, the comment that he's a well-meaning elderly man with a poor memory, that's problematic, and that could be seen as something disparaging and inappropriate. And importantly, the threshold question is irrelevant, right? Because whether Biden gives you that appearance or not as the prosecutor, that's not relevant to whether he committed the crime or not. And as you and I just discussed, just because we think he may be sympathetic, in front of the jury, that's not a reason either. So statements like that are problematic that he made. I mean, he's not a doctor, and media is playing it like he made a medical diagnosis on him. So that part's definitely problematic and could even be the subject of an ethics complaint within DOJ for him. But the bigger question of, this sort of nuanced, gratuitous slamming and slanting the way it's set up, that would be hard to point to and say, this just isn't right because of a particular reg. That's more of an overall tone thing. And that in some ways is kind of like the cleverness of the way it was written. And in other ways, it really comes down to, for Garland, what do you do if you know this is wrong the way it's done? He has a couple options. He doesn't have to say rewrite it and I'll rewrite it and then get blamed for, he took the pen himself. He could put out a summary. Nothing stops him from, if we remember what Barr did, getting out ahead of the Mueller report and kind of like slanting the whole thing before the report was released. He could have delayed that release and given a summary. I mean, he could have decided we're very close to the political season right now. It's important for the American people to know the president's been cleared, and I'm going to put out a summary that says that, and we're going to hold off on the actual raw report until later. Now, of course, he would have, been slammed for like helping Biden not releasing and all that stuff, but that's perfectly fine for him to do. But instead, what he did was he didn't do anything really. He just was like, "Hey, I'm hands off here because that's my thing," and he just let this go out. And I think that's a mistake. No question, it was a tough position to be in, but hey, that's what you get paid the big bucks for with the big office. I mean, that's the call that he should have made, because unlike the independent counsel investigations, the special counsel you should be thinking of as a regular DOJ prosecutor, and a regular DOJ prosecutor would never have been allowed to write that kind of report for public release.
I mean, Merrick Garland has definitely bent over backwards to try and not look political.
Right.
By doing so, it seems like it has the reverse effect. It makes everything political, because sometimes you actually have to counterbalance something that is so highly political, and he just won't do it. He can't, I don't know, he won't do it. And I look back to the fact that they waited so long before they investigated January 6th, right? And appointed a special counsel there. I mean, the only explanation for waiting as long as they did and not starting that investigation right away was because they didn't want to look political. And by doing that, now look at where we are, right? We're getting close to the election. And now with the presidential immunity question has made it so that case, the Tanya Chutkan Washington D.C. case, might not happen in time. I mean, it's just really, I understand the instinct to want to bend over backwards to not look political, but as a result, everything's just very one-sided. It feels like, and this was just shocking to me. What do you think what do you think the timing of her report? Like, why now? Why did it drop now? Do you think they were waiting, for example, for the DC Circuit on presidential immunity? Do you think that was important? Because, part of me wonders, because how could they determine criminality or not criminality before they know the answer to that question? I don't know. It just seems very timing wise. I don't know.
That's actually a great point. I don't think that's been discussed very much, the timing of the immunity issue, because you're exactly right. I mean, if the DC Circuit were to have come down and said there's a very broad presidential immunity period, like, how could you possibly have come down on this side? You ought to wait for that law to be factored in. I think that's a really great point, and does raise big questions about the timing. I mean, her can simply say, look, we're trying to do this as quickly as we can. We were done, so we're releasing it. But again, there would have been a very obvious point to wait for that law to be clarified. And again, putting it back on Garland's desk, he could have said, hey, how can you even reach these conclusions? I get your factual findings, but don't you think we need to wait for the Supreme Court to rule on whether anything could be done? Doesn't matter what you find, because you'd have to put that in your report, which is, we think that we found criminality, but you can't charge him because of the Supreme Court's decision on immunity. So I think that's a really important point and raises suspicions about the timing. I mean, you have this timing situation where the DC Circuit, came out against Trump, and there's a lot of publicity about that. And do you want to drop this right now to sort of counter that? So those are definitely things that factor into it. And of course, DOJ is sensitive to timing. That's why they have that rule that if it's like too close to the election, you don't want to announce anything. Really, that's why ages ago in the Nixon era, they came up with a rule that says we won't prosecute a sitting president. I mean, some of those things ought to be revisited too. I mean, most of the time, prosecutors aren't going to decide to charge a sitting president over some policy dispute. Someone's claiming that they've done all these things wrong. But does it really make sense that if you had a sitting president who commits like a street crime, Trump's famous, idea he can shoot somebody on Fifth Avenue, and in the movies, I mean, they get arrested right away. I mean, why would DOJ say, okay, can't do anything about that? So these are all sort of like issues that, because of the extreme situation that Trump has brought, causes people to revisit these questions. But that timing is very suspect, and Garland could have adjusted to say this is too volatile right now, and I have good legal reasons. He's a former DC Circuit judge. I have good legal reasons to wait to know what the law is here before we release this memo, which obviously has to apply the law to the facts. So I think that's a really great point.
Do you think so? The media characterized this as special counsel found that Biden willfully retained classified documents. Explain, do you agree with that? Explain how willful, what that, talk to us a little bit about that word willfully.
Yeah, I think that's a misleading headline based on, I don't know whether they're looking, for clickbait essentially, or whether they genuinely were misled by.
They wanted clickbait. Report. They should have said Taylor Swift.
Taylor Swift concluded that Biden.
Yeah, seriously, you might as well have said that, because it bears the same resemblance to
right.
To truth and facts. But anyway, sorry, I interrupted.
Yeah, no, I mean, here's the problem. The correct thing to say really would be that the evidence we found does not support willful retention. That's the correct legal conclusion.
That's the part I had to keep going back and read, by the way. That's what I didn't understand, is how can the media be saying evidence was found that he willfully retained classified documents? And I kept going back to the report, because I'm like, that is not what that if you found that, then you should have charged him. Right.
There, again, Her may have deliberately done this, likely, but the way the media is getting confused is this notion of, this goes back to things that in law school would make my brain blow up, but this notion of, did you deliberately do the action versus you had criminal intent for the action? Okay. So Biden did not I meant to pick up the box of cleaning items, and instead I picked up the box of classified documents. I didn't even mean to do that. That's kind of like the common sense notion. I did it by accident. I tripped, kind of. In real life terms, it sounds like he understood he may have had some classified documents. His notion of it was his personal notes, handwritten notes, those were okay to take. So it's not that he took his notes by accident, but that's totally not willfully retaining them under the meaning of the criminal statute. And that's what the media has totally blundered in terms of picking up that difference. No one's arguing that he did it by accident. The point is, what he did does not constitute, quote, willful retention, because that's a crime. And that's, maybe we're asking too much of the media to make that nuance. Maybe they don't normally.
Well, what is willful retention to commit a crime? Well, what would constitute that? If you can explain that.
Yeah, I would explain that as, you're not supposed to do this, and yet you still did it. Now, how do we prove that you know it? Because obviously most people are going to say, I didn't know it. Well, actually, the Trump case is a great example of that, which is there are repeated contacts from the archivists with your lawyers saying, hey, this stuff, you're not supposed to hang on to it. give it back to us. There's this constant flow of communication saying you can't do that, you can't do that. At some point, his own lawyers, after they get the grand jury subpoena, are saying, hey, you can't withhold certain things. That's how you show that the intent of the person was criminal. And then obviously,
How about if you ask how about if you ask one of your employees to move all of that information before before your lawyer comes and before a search warrant is executed? How's that for evidence of willful retention?
Yeah, no, that's very good evidence. Plus, asking one of your employees to like flood, the area so that everything will be destroyed.
I mean, it's true,
But
right?
yeah, I mean, but that's how you get to the willful aspect of that. That's how you have to prove the intent. And for a long time in the media, everyone says, "Oh, it's all about proving intent. It's so hard to prove the intent." But as we're seeing in what's been uncovered just in the public filings with Trump, there are some obvious pieces of evidence that would go to that, which are completely lacking in the Biden case. I mean, her accurately documents that Biden's people, as soon as they heard about anything, they went and looked for things. They turned it over. All of that utterly negates willful intent. And the way the media fails to talk about it is to say that there's no evidence of the willful intent here in the Biden case. Instead, they just say, there are differences between these cases. Biden cooperated, Trump didn't. That's not really it. I mean, the point is Biden didn't willfully do anything. There's no evidence of criminal intent. And in Trump's case, there's tons of evidence of criminal intent, and they shouldn't be afraid to say that, because just because you say there's evidence of it doesn't mean you're saying he's guilty of it, but there's evidence of it there, and there's not evidence of it when it comes to Biden.
So pivoting to Trump and Mar-a-Lago and his willful retention of national defense information, and the charges there, by the way, the whole flooding, asking your employee to flood, what was it, drain the pool or whatever and flood
Right.
I mean, it's just unbelievable to me. I remember when I was a very young misdemeanor assistant, we had like 400 cases each. I mean, it was just overwhelming. I used to work 7 days, we all did, would work 7 days a week. You'd work until midnight. I mean, it's just how you do 400 cases at a time. But this was in the early 90s. People don't do that anymore. Anyway, but I remember there was a fire once, and we all had to evacuate. It turned out to be just not very bad. And I remember walking out thinking to myself, well, if the building burns down, at least I can start over, at least it's just like, I was so overwhelmed. But then everyone was like, wait, what if someone did that? This is before computers and all that, and before everything was like electronic. So what if a defendant did it to try and make it so that everything there was no record of anything anymore? Anyway, but that's the kind of thing that you see in like a novel or a movie. The fact that that's what they did is just so unbelievable to me. I still can't get over that's how that's what they were trying to do. But I want to talk a little bit about that case and about there's so much evidence of consciousness of guilt and of guilt there that Trump actually, whether he took it on purpose or not, who knows? That I'm not 100% sure on. But he certainly kept it and retained it, and did a lot to try to hide that. But Judge Cannon, the federal Judge Cannon, who was appointed by Trump and who randomly got selected to hear the case, has been making some very surprising rulings, in particular one this week about having to reveal, Jack Smith wants to file stuff under seal about threats to witnesses, or I should say potential threats to witnesses, et cetera. And she wants to reveal the names of confidential informants, of witnesses, of investigative, FBI investigative secret information that she, what's going on there. And then I don't think a lot of people don't think that trial is going to happen in May the way it originally was. And a lot of her rulings have been shockingly questionable. Appointing a special special master, or
Right.
I can't remember what she called it, if it was a special master or
Mhm.
something else, to review the information recovered in the search warrant, just all kinds of weird decisions. What is your perspective on that?
I thought that opening move that she made with the special master was completely preposterous. I mean, it was chalk it up to inexperience, chalk it up to bad motivation, but legally it was utterly indefensible. And I'm surprised it even lasted as long as it did before the 11th Circuit really just like slam dunked on her and said, no, can't do it this way. It seems to me that she, right from the get go, has been doing things that are very pro defendant, pro Trump oriented. And I think the problem here is when they first announced that case and talking about the fast timetable, I never thought that case had a chance of getting going very quickly because of the classified documents that automatically slows things down a lot. And it would have been very easy for legitimate reasons for it to take longer than the sort of pared down version in DC that Jack Smith's trying to do with just getting to the election interference very quickly. Having said that, just as you're pointing out, a lot of her rulings just don't seem well grounded, and it seems like they're made to sort of slow things down. This latest one may have gone a little bit too far in terms of legal soundness, and I think that Smith could have a good chance. I mean, the standard for that's going to be what they call abuse of discretion, which is a pretty generous standard for a judge. But I think you could argue that when there's this um, conclusion made by the prosecutors and law enforcement that this would be dangerous to reveal these names, and yet you override that. And there's something called a writ of mandamus, which they could go to the 11th Circuit and say, you're so far out of bounds here that we're just asking the circuit, to redirect you on this point. So they might go there. And then she, of course, is sensitive to what the Court of Appeals is going to do. One thing I want to say about her behavior, because we see a lot of this chatter on social media, why doesn't Smith just move to bump her off the case to recuse her? First of all, he can't recuse her. She has to do that herself. But this idea that he can somehow file something to get rid of her on the case, you'll see a lot of, social media chatter going, okay, this is it. That Smith's going to do that. Yay. It's very hard for Smith to do that, to get her removed, to show bias. And second of all, the big problem that everyone's worried about, which is delay, that is not going to speed things up. You got to litigate that whole thing to get rid of her. Okay, fine, you got rid of her. Now you start with a new judge. I mean, we're already like 2 years down the road at that point. So there's no easy solutions here for what she's doing. But I think that it's very hard to justify a lot of things that she's done, which really raises the question of, is she just trying to slow roll the thing?
The famous quote that I can't remember who said, but everybody knows it, is justice delayed is justice denied, has never felt more pertinent than in the cases involving Donald Trump. Because if it's delayed, it will be completely denied if he wins the election. So
Yep.
I don't know, but I do appreciate very, very much that you coming on and on a Sunday, spending as much time as you are to go into depth about these issues. Is there anything else that that you can think of that I didn't ask you that you want to say about any of these issues? Anything important that we should cover before we conclude?
I think the only thing I would say is when people are thinking about this question of Merrick Garland's actions and where they want to come out on whether they agree with him or not, there are a lot of people who've done in-depth analysis and who tend to defend his actions, saying, "Oh, there were people in the FBI wanted to slow down the investigation on Trump. Don't blame Garland for that." Those are important facts to know because there were people holdovers from the Trump administration. There are folks in the FBI who, for whatever reason, didn't want this to happen. But the bottom line is when you are the Attorney General of the United States, that buck stops on your desk. I mean, Reno famously, like her second day in office was that disaster in Waco. And the first thing she said was, the buck stops here. I mean, this is my responsibility. I have to deal with it. And that's, in my opinion, why the blame ultimately does go to Garland for the delay in these cases. And, as you're pointing out, it's very, very dangerous delay for democracy.
Yeah, it really is. Shan Wu, thank you so, so, so much. I cannot tell you how appreciative I am
Oh,
that you are spending so much time to help get the truth out, because people need to, especially on what's going on right now. The more people who we can share the truth with, and what the law is and what it isn't, I think the better. So thank you so much for joining, and it was such a pleasure to spend today with you.
no, you're very welcome. And thanks for doing this.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.